From the Nifty Studios and Due Diligence Productions comes the latest episode of Tales from the Trenches, dramatizations of cases ripped from the advance sheets. Today's episode, Hidden Camera. And here now, your narrator.
Welcome, dear listeners. Our story begins innocently enough in county court at pretrial hearings. Our hero, ADA Christine Blair, is ready to go.
Are the people ready for the hearings?
Yes, Your Honor. However, I would note for the court that we have just been provided with an additional body camera video, and we have turned that over promptly to the defense today.
It seems that one of the responding officers had activated his body camera twice during the incident. This resulted in 2 videos relating to the case being made. However, only one video had previously been provided to the ADA by the police. That video was turned over to the defense as part of automatic discovery. The second was found during the officer's prep for the hearing.
Of course, if the defense needs time to study the second video, we have no objection.
I'm very busy, counsel. Let's adjourn the case for that purpose for about 6 weeks. I'm sure that will be plenty of time for the defense to examine the second video.
Instead of reviewing the video, defense attorney Joey Gallo files a motion arguing for the invalidation of the People's Certificate of Compliance pursuant to CPL 245-50, Subdivision 1, and for the release of the defendant from custody pursuant to CPL 30-30, Subdivision 2. We join the parties back in court.
Mr. Gallo, please tell me about this motion.
Yes, of course, Your Honor. And how are you on this very lovely day?
Get to the motion, Mr. Gallo, please.
Gladly, Your Honor. It's really very simple. As I point out in my papers, I seek the invalidation of the People's Certificate of Compliance pursuant to CPL 245-50, Subdivision 1, and also my client's release pursuant to CPL 30-30, Subdivision 2A. I really should be entitled to these remedies because of the people's very late disclosure of the body camera video, regardless of any good faith or due diligence that they may have shown.
Mr. Gallo, can you point me to any specific case or legal authority for this position?
Mr. Gallo explains to the court that CPL 245-50, Subdivision 1, requires that the Certificate of Compliance state that all known material and information subject to discovery has been disclosed and made available, except for items that are lost or destroyed as provided by CPL 245-80, Subdivision 1B.
The narrator is exactly right, Your Honor.
Well, since she's doing such a good job, let's have the narrator finish your argument, Mr. Gallo.
Thank you, Judge. Mr. Gallo argued that the prosecutor's good faith and due diligence are irrelevant to this analysis, and he has also requested sanctions pursuant to CPL 245-55 and 245-80. Finally, he requests that the defendant be released pursuant to CPL 30-30, Subdivision 2, because more than 90 days have elapsed before the filing of a valid statement of readiness.
Well, Mr. Gallo, that is a lucid, intelligent, and well thought out argument.
Oh, thank you, Your Honor, for granting my...
Not so fast. Why don't we hear from the people first?
Thank you, Judge. After researching on Prosecutor's Encyclopedia, especially Discovery Digest and the Dreyer memos, the law simply does not support defense counsel's argument. The people acted reasonably and with due diligence and in good faith in providing the late disclosure of the second video. Here's why. Before the defendant's arraignment, the arresting officer gave my office a list of all the police officers involved in the defendant's arrest and noted if they wore a body camera. The people requested all the body camera footage, and that was provided by the police department. All of that was turned over to the defense as part of the initial discovery package. However, during our prep of one of the officers for the pretrial hearings, we learned that he had activated his body camera twice during his work at the scene. The list from the PD didn't specify that the officer had made 2 videos. Simply put, the officer's name was on the list as having a body camera and we got a video for him, but simply weren't aware there were 2. Once we were made aware, we turned it over. Clearly, the people acted with due diligence in getting the discovery and filed the certificate of compliance and statement of readiness in good faith.
The judge considered the arguments, and after a cup of coffee, the judge rendered his decision.
Counsel, this is the court's decision. The CPL clearly contemplated situations where not every single item of discovery would be turned over prior to the filing of a certificate of compliance. CPL 245.60 provides that if the prosecution subsequently learns of additional material which it would have been under the duty to disclose, it shall expeditiously notify the other party and disclose it. Further, CPL 245.55 provides that no adverse consequence to the prosecution shall result from the filing of a certificate of compliance in good faith and reasonable under the circumstances. And finally, CPL 245.80, subdivision 1A, provides for sanctions for late discovery if it has caused prejudice to the party.
Oh, I don't like where this is going.
We now join ADA Christine Blair as she finishes recounting the judge's decision to her excited colleagues around the lunch table. Oh, please tell us more.
Oh, this is
Christine, you're
great.
awesome!
Finish the story!
Well, then the judge rules that good faith, due diligence, and reasonableness under the circumstances have to be considered. He said that our facts showed we took reasonable steps to get the discovery and that we didn't realize the officer made 2 videos until prep, after which we disclosed it promptly.
Wow, you are so smart.
I love the law.
Hey, can I second seat you?
And there was no prejudice to the defendant because he had ample time to review it because the judge adjourned the case before the hearing started. So the court denied the defense motion in its entirety.
And so ADA Christine Blair prevailed, and the defense motion was denied. This has been another exciting episode.
Excuse me, Mr. Announcer.
Oh.
There is some exciting new law on this subject.
Oh, well, certainly, Judge. Go right ahead.
Thank you. The legislature has added CPL 245.50 subdivision 1A, which becomes effective on May 9th, 2022. This section now requires a supplemental certificate of compliance to explain any delayed disclosures so the court can determine if the prior certificate was valid. The statute also states that filing a new certificate does not invalidate the previous certificate if filed in good faith and after exercising due diligence, or if the additional discovery did not exist when the original certificate was filed. This was exactly my decision in this case. I'm so happy the legislature agreed with me.
Oh, well done, Your Honor. This has been another...
Wait, there's even more. CPL 245.50 subdivision 4 has also been added, and it requires the party who receives discovery and a certificate of compliance to alert the opposing party of any potential defects they know of as soon as practicable.
Again, outstanding, Judge. This has been another...
One more thing.
Oh.
CPL 245.80 has also been amended to require that remedies for belated disclosure be appropriate and proportionate to the prejudice suffered. The section states that dismissal is only appropriate where all other remedies have been considered and dismissal is proportionate to the prejudice suffered. Pretty much what I said too. Oh, do I hear the appellate division calling?
Well, thank you, Your Honor. If I may continue. This has been another.
And another thing. Oh, no, I'm only kidding. Go ahead.
You are hilarious, Judge. This has been another exciting episode of Tales from the Trenches. Today's drama was inspired by the case of People v. Henry, decided on April 11th, 2022, from the Supreme Court of Richmond County, also known as Staten Island. Today's performance was written, directed, and produced by your friends here at NIPTY. To see this case and other Discovery case law and resources, be sure to visit NIPTY's Discovery Digest. And so be sure to join us for our next episode of Tales from the Trenches, when we hear Joey Gallo say, good morning, Your Honor. I have here a new motion you're just going to love.
Oh, is it too late for me to call in sick?
So long for now.